Good morning. Very fantastic judgment, and all young lawyers and particularly practicing advocates in criminal side must read the judgment para by para, because the judges are trained to explain how omission and contradictions be elicited by cross-examination. It's a case of murder case wherein they have also passed a dictum of judgment that last seen theory should be within the proximity of time. That it was also there. This is the AR 2024, Supreme Court 2283. AR 2024, Supreme Court 2283. Aladdin and others versus State of Assam and another. The first ratio is that while recording contradictions, trial court did not mark witnesses' prior statement based on which they were sought to be contradicted in cross-examination. So they say, then again they say, the last seen theory must be in proximity of time at which dead body was found. So that these two things are there. But you see, the judgment describes the way of how 161 statement CRPC say that statement should not be signed and it should not be used for evidence, but subject to certain exceptions. So you must go through the 162 statement. Those exceptions are when you are invoking 145 Evidence Act to contradict the witness that he is deviating from earlier statement. Then section 32 of Indian Evidence Act, dying declaration, and then they say what was the omission. The witness deliberately omits certain things before the court, contradicting his earlier statement. That omission must be very vital. They say that's what they say. The 164 statement, 161 statement, all should be earlier statement. So how to cross-examine 145 cross-examination is also, they say there were two type. Number first one, you must say that he had earlier given some statement. That's after that is one factor. Thereafter, you may refer the portions which he deviated from his earlier statement. That is called. So contradictions, omissions are there, and improvement. Sometimes he may improve. He may say knife in the 161 statement, and before the court he may say long knife. So that long is an improvement, and that was also omitted when his statement was recorded by the court. Then you see 155 Evidence Act also been discussed here, stating that if a witness is contradicting his earlier statement, so that itself is sufficient to impeach his with credit. That means he is not reliable. Then they have also discussed about Tahsildar Singh versus State of UP case, which deals with this 145, 161 statement. So first of all, that I have read this, you have to go through the judgment. Please go through the judgment. Judgment is not that much of but it is very vital. They have given some explanations also about what was the statement given to police official and how he contradict his earlier statement, stated something different before the court. That was also discussed at para 10. And again they have also discussed about para 12. And if you go through this slowly again and again, you can understand how to conduct cross-examination. First of all, the police has to file 173 final report. Final report, 173 final report is part and parcel of 172 case diary. but the prosecution need not file all the statement or material collected and kept in 172. The prosecution is authorized to file only the witnesses and statement and materials he relies for to prove his case. So then the 161 statement are being recorded by the police officers and signature is not being obtained, and that is not used as evidence. But the papers are given to you stating that these witnesses had stated like this before the investigating officer, and relying that they filed final report. So because those statements are not evidence and they could be marked as evidence, you can only mark it under 145 Evidence Act, if any contradictions is there. So this judgment says two different way of bringing this 161 statement on record. They say at the time of cross-examining the witness, if the witnesses has omitted to say something or contradicting some different statement before the court, then that portion should be marked. That was the judgment says. Number one. Number two, if he denies that totally, then you have to go to investigating officer who has got file with him and put him a question that whether these witnesses had stated so. So these part, to understanding this area of cross-examination, you have to again go through the CRPC and these judgments deeply, so that you can cross. If you are well thorough and understood this case of these judgments, verdict and guidelines, you will be the best lawyer. I hope you understand. You go through the entire judgment. This will be helpful. Best wishes.